Hi, welcome back everyone. This session is about history of trade union movement. Human needs very limited in Human needs were very limited in the early days. Only a few trades and occupations were taken up by the people. The Industrial Revolution started in Britain in the 18th century. It brought changes in the culture and civilization of human beings. The rapid growth of population increased human wants and demand of goods. Lifestyle of the people also changed. Development of science and technology helped industrialization. The institution of social security was felt on industrialization and growth of society. The Royal Commission on Labour made a comprehensive survey of the problems relating to the labor. A number of recommendations were made, including social security. Social security means a guarantee provided by the state against certain risk. Now, the concept of social security is based on human dignity and social justice. The labor legislation in India has been enacted to achieve such objectives. It promotes the conditions of laborers, keeping in view the development of industry and national economy. The industrial adjudication has become necessary to reach the ends of social and economic justice. Many enactments have been made in India to secure labor welfare and incidental objects. Labor laws in India have developed in view of awakening of the workers of their rights. Many industries were established both in the public and private sector after independence. The Constitution of India has provided several provisions for the welfare of the laborers. The legislative and judicial processes have to fulfill promise to keep the industrial peace in the country. Social and economic justice is the ultimate ideal of industrial adjudication. It would help establish harmony between the parties to the dispute. The Parliament and the states have enacted several labor legislations from time to time. The following are some of the important labor laws in our country. That is the Industrial Disputes Act 1947, the Trade Union Act 1926, the Workmen's Compensation Act 1923, the Factories Act 1948, the Minimum Wages Act 1948, the Employee State Insurance Act 1948, the Payment of Wages Act 1965, the Payment of Bonus Act 1965, the Payment of Gratuity Act 1972, Maternity Benefits Act 1961, Motor Works Act, then Apprentices Act 1961, Equal Remuneration Act 1976, and the Industrial Employment Standing Orders Act 1946. The Trade Unions and Indian Constitution. Labor is a subject in the concurrent list under Constitution of India. Therefore, both the central and the state governments are competent to enact legislations. A large number of labor laws have been enacted as a result to cater to the different aspects of the labor. The different aspects are: the first one, occupational health, safety, employment, training, and apprentices. The second, fixation, review, and revision of minimum wages. The third one, the mode of payment of wages, payment of compensation to workmen who suffers injuries, disablement, or death. The fourth one, bonded labor, contract labor, women labor, and child labor. The fifth one, resolution and adjudication of industrial disputes. The sixth, provision of social security such as provident fund, employee state insurance, gratuity, and the seventh one, provisions for the payment of bonus, regulating the working condition of certain specific categories of workmen such as plantation labor, BD workers, and so on. Now, labor laws enacted by the central government, where the central government has the sole responsibility for enforcement. The first one, the Employees State Insurance Act 1948. The Employees State Insurance Act 1948. The second one, the Employees Provident Fund and Miscellaneous Provisions Act 1952. So the second one is the Employees Provident Fund and Miscellaneous Provisions Act 1952. The third one, the Dock Workers Safety, Health and Welfare Act 1986. Once again, the third one, the Dock Workers Safety, Health and Welfare Act 1986. The fourth one, the Mines Act 1952. The Mines Act 1952. The fifth one, the BD Workers Welfare Fund Act 1976. The fifth one, the BD Workers Welfare Fund Act 1976. And the sixth one, the Cine Workers Welfare Fund Act 1981. The Cine Workers Welfare Fund Act 1981, and so on. Labor laws enacted by the central government and enforced both by central and state government are as follows. That is, the Child Labor Prohibition and Regulation Act of 1986, the Contract Labor Regulation and Abolition Act 1970, the Industrial Disputes Act 1957, the Industrial Employment Standing Order Act 1946, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, the Payment of Gratuity Act 1972, the Payment of Wages Act 1936, and so on. So all these were enacted by the central government and enforced both by central and state governments. Now, some of the statute were the labor laws enacted by the central government and enforced by the state government. Those are the Factories Act 1948, the Motor Transport Workers Act 1961, the Plantation Labours Act 1951, the Trade Unions Act 1926, the Workmen's Compensation Act 1923, the Bonded Labour State Abolition Act, the Bonded Labour System Abolition Act 1976, and so on. So, the trade unions with respect to Indian constitution comes under the concurrent list, which shows that the central government and the state government can make laws. So here mostly we are going to discuss about the laws enacted by central government, and these are, we have many laws that are enacted by the central government. With respect to enforcement, we have two categories, that is enacted by the central government and enforced by both central and state. Then we have those labor laws enacted by central government and enforced by the state government. Now, definition of trade union. It is difficult to manage the workers individually in large industries which employ hundreds of workmen. The position of workers was poor and they had no bargaining power. A workman stands in a weaker position than his employer in an individual bargain. The employer stands in a better position to dictate the terms of employment. The individual workers were forced to accept the offer without any reservation. The position becomes different if the same bargain is made by a group of workmen. The workmen can secure better wages and greater security for themselves. Hence, trade unions are necessary to protect the rights of a worker and make good their bargain. The trade unions are determined to fight in the struggle for economic equality. The workers organize themselves in the form of trade unions. The Trade Union Act was passed in the year 1926 and came into force on 1st June 1927. It provides for the registration of the trade union and defines the law relating to it. Flippo defines trade union as follows. A labor union or trade union is an organization of workers formed to promote, protect, and improve through collective action the social, economic, and political interest of its members. So, this is the definition given by Flippo. Once again, a labor union or trade union is an organization of workers formed to protect, promote, and improve through collective action the social, economic, and political interest of its members. So, once we dissect the definition of Flippo, there are some key ingredients. That is, this is an organization of workers. And why is it formed? It is formed to promote, protect, and improve. And how? Improve the social, economic, and political interest of its members. And through what medium? Through a collective action. So the key ingredients with respect to this definition is that a trade union or a labor union, first one, it's an organization of workers, and the second, it is formed to promote, protect, and improve the objects. And the objects, what are the objects? It's to the social, economic, and political interest of its members, and the medium is through a collective action. So these are the key ingredients with respect to Flippo that defines Flippo definition of trade union. Now, Dale Yoder defines trade union as follows. Dale Yoder. Now, a trade union is a continuous association of workers which is formed with the purpose of protecting the interest of workers. So, the definition of Dale Yoder is a bit more simple, including which is inclusive of all the ingredients of that was termed by Flippo. So, by Dale Yoder, a trade union is a continuous association of workers which is formed with the purpose of protecting the interest of workers. So, let's dissect the definition of Dale Yoder. So, here the first ingredient is continuous association of workers, and the second one formed with the purpose of protecting the interest of workers. So these are the two ingredients with respect to Dale Yoder in the Dale Yoder's definition of trade union. Now we have discussed the definition given by Flippo and Dale Yoder. The Flippo definition is more elaborate and more easy to interpret and understand, because Dale Yoder the definition seems like a wider ambit. Now, Section 2, Subclause H, Section 2, Subclause H of the Trade Unions Act 1926 defines trade union as follows. So, we are going to look into the statutory definition that is given in Section 2, Subclause H of Trade Unions Act 1926. Any combination, whether temporary or permanent, formed primarily for the purpose of regulating the relations between workmen and employers, or between workmen and workmen, or between employers and employers, or for imposing restrictive conditions on the conduct of any trade or business, and includes any federation of two or more trade unions. So that is the definition, statutory definition given in Section 2, Subclause H of Trade Unions Act 1926. So let's dissect this definition to find the key ingredients in this definition, that is a statutory definition. So here it is said that the first ingredient is that it is any combination, and this combination can be temporary or permanent. Now, why is it formed? That is the second ingredient. So the primary purpose is for regulating the relationship, and the third ingredient is what kind of relationship. So three kind of relationship is mentioned here, that is between the workman and workmen. The second one is between employers and employers, and the third one workman and employer. So three kind of relationships are described, that is workman and workman, employer and employer, workman and employer. So that is the kind of relation discussed. And the next ingredient is what kind of regulation, that is for imposing restrictive condition on the conduct of any trade or business. And what can it include? It can also include any federation of two or more trade unions. So the main ingredients of the statutory definition for trade union is that it can be any combination, and it can be of a temporary nature or a permanent nature. And the second ingredient is what is the primary purpose of its forming. The primary purpose is that to regulate the relationships. And the third ingredient is what kind of relationship. So three kind of relationship is discussed here, that is between the workman and the employer, workman and workman, employer and employer. Now we said the second ingredient as regulating the relationship. And how is it regulated? That is a fourth ingredient, that is imposing restrictive conditions on the conduct of any trade or business. And the fifth one is an inclusive clause, that is includes any federation of two or more trade unions. So the statutory definition given under Section 2 Subclause H of Trade Unions Act that defines trade union can be dissected to form 5 key elements, and that is what we discussed right now. Now the above definition speaks about the three different relationships, that is between workmen and employers, workmen and workmen, and employers and workmen. The feature of a trade union, as per the definition under the Trade Unions Act, are as follows. The first one, any trade union is an organization formed by employees or workers. The second one, it is a permanent body formed on a continuous basis. The third one, it intends to protect and promote all kind of interests of its members such as economic, political and social. The fourth one, it includes federation of trade unions as well. And the fifth one, collective action is the basic weapon to achieve its objectives. Now, section 16, 17, 18 and 19. Sections 16, 17, 18 and 19 of the Trade Union Act 1926 deal with the immunities available to the trade union in respect of criminal and civil proceedings. So once again, section 16, 17, 18 and 19 of the Trade Unions Act 1926 deal with the immunities available to the trade union with respect of criminal and civil proceedings. It includes in the law of torts for acts committed by them in connection with union activities. Now, section 2 subclause G. So, we discussed the definition of trade union in section 2 subclause H, and section 2 subclause G of the Trade Unions Act 1926 defines the word trade dispute. So, and it goes as follows. Any dispute between employers and workmen, or between workmen and workmen, or between employers and employees, which is connected with the employment or non-employment, or the terms of employment, or the conditions of labor of any person. And workman means all persons employed in trade or industry, whether or not in the employment of the employer with whom the trade dispute arises. So, section 2G of Trade Unions Act 1926 defines trade dispute. So, let's dissect the definition of trade dispute. It can be, the first ingredient is that it is any kind of dispute. And then the second ingredient says that between whom this dispute shall be, if it is to be brought under trade dispute. So, again we have three category of people, that is employers and workmen, between workmen and workmen, and between employers and employers. Now, the third ingredient shall be what kind of dispute. So, it can be connected to the employment or non-employment, or terms of employment, or the conditions of labor of any person or person in that industry. So, that is the main three ingredient. Then we have the fourth ingredient, which says that who all can be called as a workman. So, workman means all persons employed in trade or industry, whether or not in the employment of the employer with whom the trade dispute arises. So, these are the four key elements with the definition of trade dispute given under section 2 subclause G. And it is to be noted, under this section, what is inclusive of workmen is also defined. So, section 2 subclause G defines trade dispute and also throws light into the interpretation of workmen. So, with respect to statutory definition of trade union under section 2H, we dissected it with 5 key elements, and the section of 2G that defines trade dispute, we dissected it with 4 key elements. So that is with this session, which is a brief history of the trade union and the labor laws. So the next will be covered in the next part of this series. Thank you. Stay tuned. Like, comment and subscribe. In the comment box, please let me know this which subject or which statute you would like me to do a discussion on, and please click on that bell icon so that you can stay updated and get a notification once I upload my next session or a podcast. Thank you for your support and thank you for listening. Bye. Take care.